Good evening. I'm honored to welcome you here on behalf of the Law Society of Upper Canada and the Ontario Bar Association. We're here to address the legal issues that flow from the events of September 11th, events that have become a turning point for North America. It's one of those events that has a lasting effect on everyone. I will never forget where I was and what I was doing when I first heard of the attacks of September 11th. All of us watched in horror and in shock, and we can all still see the images of a jet flying into a trade tower, people jumping from burning buildings, and huge structures crumbling into dust and rubble. So we have mourned the following. We've assisted their families, and we've pledged Canadian resources to combat terrorism so that this will not happen again. Tonight, I welcome a panel of distinguished guests who will address various aspects of the Canadian response to September 11th. I'm delighted to introduce your moderator for the evening, the Honourable Mr. Justice Corey. He was called to the Bar of Ontario in 1950, practiced law with Holden Murdoch, and was appointed a QC in 1963. Justice Corey has been a bencher of the Law Society of Upper Canada, chairman of the Ontario Civil Liberties Section of the Canadian Bar Association, past president of the County of York Law Association, past national director of the Canadian Bar Association, and past president of the Advocate Society. Apart from his legal work, Justice Corey has been a pilot in the RCAF, and he served overseas with the 6th Bomber Group. He is also an honorary colonel of the 426th Training Squadron. But all of us know Justice Corey best for his outstanding judicial work over 25 years on the bench. He was appointed to the Supreme Court of Ontario High Court in 1974 and to the Ontario Court of Appeal in 1981. In 1989, he was appointed to the Supreme Court of Canada, where he spent a decade and had much to do with breathing life into the Charter of Rights. Ladies and gentlemen, please join me in welcoming Mr. Justice Corey.
Tonight, the order of business will be this, that each speaker will speak for 15 minutes. And at the end of that 15 minutes, I'll appear like a friendly apparition at his or her side to introduce the next speaker. At the end of the evening, there will be, I trust, questions from the floor for members of the panel. I should say at the outset that Mr. Saeed of the Muslim Lawyers Association, I trust, will have the first question. That it was an oversight that his association wasn't recognized to be part of the panel, and certainly will be welcome to give their comments, questions with regard to this evening's process. The first speaker is Mr. Morris Manning. Mr. Morris Manning is one of our eminent counsel. I can tell you that he was always welcome into the court in Ottawa and the Court of Appeal here, and his presentations were always extremely helpful. In addition to his very busy litigation practice, he has edited Dominion law reports and Canadian criminal cases, and written a number of papers and texts, and is co-author of what I think is an outstanding text, the only Canadian text on criminal law with Alan Mewat. His views with regard to what has happened will indeed be welcome. It is a difficult time there is always action and reaction. The reaction to something tragic that has happened has manifested itself in government legislative action. And the approach to that should be balanced, careful, and as in every situation that's difficult in a democratic society, in this wonderful country of ours, it is important to hear both sides and to listen to all that can be said with regard to this matter for making up our minds and taking position with regard to it. I'm very pleased to then call on Mr. Mann.
I'm going to attempt to do what this bill seems to allow prosecutors to do. I'm going to attempt the impossible. The invitation to address you on the highlights of the bill came from Deborah McAllister, who asked me to analyze the bill in detail. The bill has been analyzed in detail at a recent conference at the University of Toronto Law School by over 24 academics speaking for 2 days. I'm going to digest some thoughts with respect to this bill. The bill is an extension, as I see it, and an expansion of procedures placed in the criminal code in an attempt to redress many social situations. The expansion of powers to obtain warrants and wiretap authorizations in the general, quote, fight against crime, and the creation of new offenses such as enterprise crimes and money laundering and anti-gang crimes have been developing over the years, and the government has tacked on to that recent spate of legislation the anti-terrorist bill. A study of this bill, and it'll become law very shortly, reveals what I feel is a failure to understand the limitations in utilization of criminal law and the need to utilize not only existing laws but existing resources. We have a long history in this country, unfortunately, of adopting legislation that others have not wanted. We did it in 1892 when the British didn't want the Stevens Draft Code. In 1974, we adopted the then called Protection of Privacy Act. Now it's part of the criminal code called under the title Invasion of Privacy, and it was the bill that was rejected by the U.S. Congress. We have watched repeatedly while the Supreme Court of Canada has affirmed, for example, the totality of the entire regime of protection as a whole of the wiretap provisions, and then watched in silence, as it were, while Parliament took away some of the mainstays of what the Supreme Court has said for 20 years were the vital protections. This legislation is designed to achieve an objective. We can't gainsay that objective because that's the objective of our elected officials. But what we can do is look at the product and say, is it going to achieve that objective? Is it going to help us really get the terrorists? Is it really going to help us establish peace and security? Is it really an anti-terrorist solution? Unfortunately, I don't think it is. And what I do think will happen is that it will increase litigation, it'll increase the length of trials, it'll raise constitutional issues of vagueness, and so on. It creates new offenses. It expands the powers of investigation and detention. It combines these with powers to order investigative hearings, which compel people to assist police by forcing appearances before judges in secret chambers, where while they can have a lawyer present, the lawyer's not going to do them any good because the lawyer has to tell them that they have to answer the questions or they're going to go to jail. The bill allows police officers to lay information before provincial court judges on the basis of suspicion rather than reasonable and probable grounds, on the basis that an imposition of a recognizance with conditions is necessary to prevent the carrying out of terrorist activities. And in order to accomplish this, let me take you to some of the more salient parts of the bill. The bill constitutes a reaching out, not only of jurisdiction, because acts committed in many parts of the world are now deemed to be offenses in Canada. It reaches out by increasing the statutory, although I doubt that it's constitutionally valid, but that's for argument all the way up to the Supreme Court of Canada, by allowing the Attorney General of Canada to prosecute a myriad of new offenses under the Criminal Code. It would be different if the legislation stayed as an act of Parliament quite apart from the Criminal Code, but this legislation is part of the Criminal Code, which means that the primary constitutional responsibility under the Constitution Act 1867 is that of the Provincial Attorney General. And traditionally, that area has been jealously guarded, but surprisingly, the Provincial Attorneys General have been quiet on this issue. We haven't heard them say anything about the inroads into their bailiwick. And the inroads are substantial because the creation of offenses is numerous in relation to not only what is a terrorism offense, but because of the broad definition, terrorism offenses is dependent on terroristic activities, and the reference is to any indictable offense that has part and parcel terrorism activities. Well, that includes many, many offenses in the Criminal Code, including murder, that have been traditionally prosecuted by provincial attorneys general. Now the Attorney General of Canada says we can come in and we can prosecute. In addition, the amendments to the Canada Evidence Act, abolishing or replacing sections 37 and 38 and 39, have a very interesting provision which allows the Attorney General by fiat to come into any prosecution where the Attorney General feels that there is information that might be revealed as being injurious to public security, for example, to national security. The fiat comes into a prosecution, is presented to the prosecutor, and that prosecutor no longer has jurisdiction to prosecute. That's going to create a very interesting constitutional battle should the provincial attorneys general wake up and realize that their whole area of jurisdiction is under attack. Same thing happened many years ago in cases of Peltier and Hauser and CN National Transportation and so on, and that will happen again. Why the federal government felt it necessary for the Attorney General to prosecute remains something that hasn't been completely revealed. Much has been made of the breadth of the definition of terrorist activity because it tracks certain language dealing with religious and ideological matters. When that was put forth, an amendment came recommended by the Senate committee, but the question arises as to whether the amendment does us any good. In my view, unfortunately, the bill incorporating the definition of terrorist activity and the amendment stating for greater certainty the expression of a political, religious, or ideological thought, belief, or opinion does not come within the definition of terrorist activity unless it constitutes an act or omission that satisfies the criteria of that paragraph. It's referring to the paragraph in the definition that talks about political, religious, or ideological thought or belief. Now, the Honorable Irwin Cotler, who, as we've seen in the media and at the U of T conference, who in fact is well respected across Canada, and rightly so, and who has the ear of the Minister of Justice, as she's indicated that his views are extremely important, even he could not convince the government to take out the motivational language that talks about expression of political, religious, or ideological thought or belief. The government is committed to that. And that broad part of the definition might ensnare innocent people who want to protest. Now, despite the amendment, it's my view that a legal protest or a strike that disrupts essential services and violates various laws and regulation, and where that happens, there might be a causing of a risk to the health or safety or property of others, that comes within the expanded definition of terrorism. The for greater certainty clause, I think, doesn't do any good, doesn't help relieve the anxiety of those who engage in those demonstrations. While the intent of the legislation, of the amendment, was to ensure that protest activity, whether lawful or unlawful, would not be considered terrorist activity unless it was intended to cause death and so on, we all know from our experience in this business that the intention of today gets lost in the judicial interpretation of tomorrow. The judges will look at the situation 10 years from now, and they will see a body of case law that may well encompass the kind of individuals being charged whom the government of the day today never intended. It's not merely the intention of the government, it's what the language in its application to the particular prosecution will bear. In addition to the broadness of the definition, which brings in a very broad range of activities in relation to the investigative as well as the charging process, there's a piling up of inchoate liability on top of inchoate crimes, and the ability to prosecute these forms of preparatory crimes is a frightening expansion of the criminal law. There are new criminal offenses. Let me give you a couple of them. Participation in terrorist group activity for the purpose of enhancing the ability of the group to facilitate or carry out terrorist activities. This builds on the criminal organization provisions and the anti-gang legislation in the criminal code, but the prohibited acts go beyond attempts or aiding and abetting and may apply to people even if the accused has failed to enhance the ability of the terrorist group to facilitate or carry out its activities. Section 83.19 creates the offense of knowingly facilitating a terrorist activity. That raised a lot of concern. So what did the government do on the recommendations of the people that were advising the government? They put forth an amendment. Here's what the amendment does. The term facilitating, proposed, allows attempts to clarify what facilitation means without setting out a conclusive definition. It provides that for the purposes of this act, dealing with terrorism, a terrorist activity is facilitated whether or not the facilitator knows that a particular terrorist activity is facilitated, whether any particular terrorist activity was foreseen or planned at the time it was facilitated, or whether any terrorist activity was actually carried out. The rationale for the amendment, set out in the background note, was claimed to be the reordering so that the provisions clearly stated that in order to be guilty of an offense, the individual must know or intend that their act would help a terrorist activity to occur, even if the details of the activity are not known by the individual. Read that amendment. In my view, the language of the amendment ensures completely opposite to the backgrounder. Section 83.21 creates an offense which applies to direct or indirect instructions to carry out activities for the benefit of the terrorist group in order to enhance the ability of the group to carry out or facilitate their carrying out terrorist activities. In order to know what that section means, you have to go back to the definition of terrorist activity. You have to then go into the amendment to find out what facilitation is all about, combine the two, put them all together, and then if the prosecution, for example, charges a conspiracy or an attempt, You have to figure out exactly what the parameters of the offense are. When combined with the newly created principle found in the interpretation of facilitation, it expands each of these particular provisions. Knowingly instructing directly or indirectly any person to carry out a terrorist activity is an offense, plain and simple, punishable by life imprisonment. You have to put in that section the broad definition of terrorist activity. But that's not enough for Parliament now, because in subsection 2, it provides that the offense may be committed whether or not the terrorist activity is actually carried out. The accused instructs a particular person to carry out the activity. The accused knows the identity of the person whom the accused instructs to carry out the activity, or whether a person whom the accused instructs to carry out the activity knows that it is a terrorist activity. In other words, a closing off of various defenses. For an offense that carries with it the potential of life imprisonment that is dependent upon an extremely broad definition. In addition to those kinds of offenses, new offenses are added with respect to the financing of terrorism, and I won't take you through those, there isn't enough time. But if you read those sections, each one is extremely broad. Each one is potentially capable of engulfing people who are unintended terrorists, people who decry terrorism, yet people who, for example, have supplied property or goods to terrorists. As one would expect in a bill such as this, the maximum imprisonment terms are increased from around 10 to 14 and life imprisonment. Sentences are consecutive to other offenses, and theoretical disproportion of sentencing is not far off. Let me turn to the increase in police powers. There's an enlargement of surveillance powers of the communications security establishment. We now have a statutory recognition that this agency, which we long knew about, actually exists. The major problem is the expansion of its powers. All of these powers, for example, the enlargement of powers, investigative powers, wiretapping powers, are given to every police force in Canada, including the RCMP. And some, such as Professor Marty Friedland, have decried this because unlike CSIS, which has a civilian regulatory body, and however one views that particular body as doing or not doing its job, it's there, and it has certain respectable and responsible people on it. This doesn't have that. There's no built-in protection here. Wiretapping, just as they did with respect to the organized gangs, they took away the requirement of having to establish that other investigative procedures have been tried and have failed. Now that's a provision in the wiretap law that's extremely important. Interestingly enough, with respect to CSIS, it's still there, but when it comes to the anti-terrorism investigation and when it comes to the gang legislation investigation, the police do not have to show that they resorted to wiretapping as a last resort. And therein lies the beginning of the acceptance, and I'll come to this in my concluding remarks, of these procedures. First, we see it for bikers, and everyone will say, well, that's okay, because they're in a group different from everyone else. Now we see it for terrorists. What's the next group? Who is the next group? By the time things settle down, 5 years from now, it'll become ho-hum, they've just expanded the wiretap provisions. In 1974, we had wiretap provisions which guarded and protected privacy. A couple of years later, the government passed amendments to expand the list of offenses for which you could get an authorization order and started cutting away at some of the defenses. In 1993, they cut away the automatic exclusionary rule, saying, well, you've got your charter rights. Well, by that time, of course, the Supreme Court of Canada had established that in order to exclude evidence under the Charter, the defense had to jump through many hoops. That's unfortunately what happens. They have eliminated the requirement of other investigative procedures with respect to wiretapping. With respect to the communication security establishment, what is new is that the Minister of Defense is now authorized, or given the power to authorize interceptions involving persons in Canada if directed at foreign entities located outside Canada.
Think of me as a red light.
All right. Brian, or Chief Justice Dixon used to sit with his pen. Investigative hearings, compelling a person to appear in order to give evidence, arrest with warrant if they fail to appear. We have some of that today. The difference is that we don't have it until people have committed offenses. Recognizance with condition, both of which these provisions are subject to a sunset clause. Try telling a person who's compelled to give evidence that 5 years from now this provision will disappear. Arrest without warrant on suspicion, extension of time, held in custody 72 hours is the possibility. With respect to all of these matters, in 1997, I went to South Africa on behalf of a magazine to investigate how the lawyers and the judges operated in that apartheid system. I found that despite the fact that they paid lip service to the rule of law, the judges, and were enforcing what their legislative body had passed, and despite the fact that the lawyers did an admirable job of fighting these terrorism charges on the basis of administrative law principles, the system, of course, was an immoral one. But I went back to the article, and this is what I wrote. Understandably,
Better just be sort of a very short sentence.
it is. It's only one sentence.
All right.
While the trials appear to be fair on the surface, the length of detention prior to trial, the denial of civil liberties, and the vagueness of the laws that bring about so-called authority to detain an individual are difficult to accept. Thank you.
This may be the most difficult tie clip ever created. The next speaker is Catherine Corrick, who's called to the bar in 1981. And what stands out is that she took a sabbatical year to study law. Well, that's commendable anywhere, but she undertook her study in the south of France. I think that's an indication of the epitome of discrimination and good taste. She returned to work for the bar admission course, both writing and teaching. She became a director of the policy secretary to the Law Society in '96. She served as an alternate chair of the Ontario Review Board. She's currently director of policy and legal affairs at the Law Society and a member of the Federation of Law Society of Canada's National Committee on Bill C-36. In another life, I'm kind and considerate, but for speakers' times, I have to be mean and cruel, and you'll understand.
Thank you, Justice Corey. Part of my job here at the Law Society is to be sure that benchers are kept apprised of events and issues that affect lawyers as a profession. It was in that context that I began examining Bill C-36, looking for provisions that affected the legal profession and its regulation. As I went through the bill, I started making a list of the provisions that fell into that category. What struck me when I looked at the list that I'd made was not the effect the provisions had on the legal profession, but rather the very profound effect that these provisions had on the right to counsel. And it is that I want to spend the next 10 minutes or so talking to you about. I want to start with the premise that the right to counsel is a principle of fundamental justice. This basic democratic right enjoyed by all Canadians includes not only the right to retain and instruct counsel, but the right to independent counsel and to speak to that counsel in the secure knowledge that everything said will be held in confidence. In my view, there are a number of provisions in Bill C-36 that will prevent that. There are 2 sections proposed in the Criminal Code that will subject lawyers to criminal prosecution for fulfilling their professional duties in advising and representing those people and organizations subject to the provisions of this bill. Section 8303 of the Criminal Code will make it an offense punishable by 10 years in prison to make financial or other related services available, knowing that the services will be used by or will benefit a terrorist group. Other related services is not a defined term in the bill. The bill further makes an offense, and Mr. Manning mentioned this, to knowingly participate in or contribute to, directly or indirectly, any activity of a terrorist group for the purpose of enhancing the ability of the group to carry out terrorist activity. Participating in or contributing to includes providing a skill or an expertise for the benefit of or at the direction of a terrorist group. A court may further consider the fact that a person received a benefit from the group in determining whether or not the person participated in or contributed to a terrorist activity. The penalty for this offense is also 10 years in prison. Lawyers who represent individuals or groups subject to this bill clearly will provide a skill or expertise for the benefit of a terrorist group. In addition, lawyers will be retained for providing the skill or expertise, and that retainer may be considered a benefit. Lawyers could be prosecuted for participating in or contributing to the activity of a terrorist group and imprisoned for up to 10 years. There is no exemption from these provisions for lawyers who act lawfully in advising and representing clients. There doesn't seem to be a good reason for this, given that lawyers, like every other Canadian, are subject to the provisions of the Criminal Code that make things like aiding and abetting and conspiracy a crime, and that would prohibit them from assisting their clients in perpetrating crimes. Canadian lawyers are a courageous bunch and honor the principle that everyone is entitled to representation. But to expect lawyers to risk criminal prosecution is, in my view, asking too much. The requirement that the Attorney General consent to these prosecutions is, again, in my view, not a sufficient safeguard. There are other features of this bill that will affect the right to counsel as well. There are amendments proposed to the Criminal Code that will make it an offense to knowingly deal directly or indirectly in any property owned or controlled by or on behalf of a terrorist group. Entering into or facilitating any transaction in respect of that property will also be an offense. This provision will make it an offense for lawyers acting for people subject to the bill to accept retainers from their clients. Additionally, the bill will provide for forfeiture orders of property owned or controlled by a terrorist group. Lawyers' retainers held in trust accounts can be ordered forfeited. Unlike the new Proceeds of Crime Act,
money received by lawyers for professional fees, disbursements, or the posting of bail have not been exempted from the provisions of C-36. In my view, the combined effect of these provisions will make it difficult, if not impossible, for people subject to this bill to retain legal counsel, making their right to counsel illusory. Many American commentators have remarked on the chilling effect that similar provisions, such as these in the U.S., have had on the American bar. How far behind can Canada be? I mentioned at the outset the right of Canadians to independent counsel. What I mean by that is counsel who will be loyal only to them, who will not have duties to anyone adverse in interest to them, including the state. I also mentioned the importance of the confidentiality of the solicitor-client relationship. There are, again, a number of provisions in this bill, in my view, that violate these principles and require lawyers to act as agents of the state against their clients and to breach their duty of confidentiality. The bill will require lawyers to disclose confidential solicitor-client information to the state, conscripting them against their clients and making it impossible for them to act as independent legal advisors with undivided loyalty only to their clients. Section 83.1 will require everyone to disclose forthwith to the RCMP and to CSIS the existence of property in their possession or control they know is owned or controlled by or on behalf of a terrorist group. Lawyers who hold money in their trust accounts on behalf of entities that are listed by the government as terrorist groups, for example, will be forced to be witnesses against their clients and immediately disclose the existence of the trust funds to the RCMP and to CSIS. Failure to do so will subject the lawyers to fines of up to $100,000 and up to 10 years in prison. Furthermore, amendments to the Proceeds of Crime Act will expand the nature of transactions lawyers will be required to report to FINTRAC. Currently, lawyers are required to report transactions that they have reasonable grounds to suspect are related to money laundering. Bill C-36 will broaden that and require lawyers to report transactions they have reasonable grounds to suspect are related to a terrorist activity financing offense. The Act prohibits lawyers from telling their clients with the intent to prejudice a criminal investigation that they have made such a report, whether or not a criminal investigation has begun. In essence, the Act compels lawyers on pain of imprisonment to breach the fundamental principles that underlie the solicitor-client relationship and not inform their clients that their relationship has been breached. The Federation of Law Societies and the Law Society of British Columbia have recently challenged the constitutionality of the regulations to the Proceeds of Crime Act. It's Section 5 of those regulations that impose the requirement of reporting on lawyers. They've challenged it on the basis that it compels lawyers to gather and provide evidence to the state against their clients. On November the 20th this year, the British Columbia Supreme Court issued an interlocutory order exempting lawyers from the application of this requirement. In making that order, Madam Justice Allen describes Section 5 of the regulations as the authorization of an unprecedented intrusion into the traditional solicitor-client relationship. Bill C-36 will now expand this intrusion. Finally, on the point of conscripting lawyers against their client investigative hearings, much has been said about them. I don't want to repeat it all. These hearings represent not only a very disturbing departure from the fundamental right of a citizen to remain silent during the investigation of an offense, but they also amount to judicially supervised interrogations of witnesses and suspects, positioning our judiciary much closer to the police investigation stage than they've ever been before. Will lawyers be required to appear before judges to answer questions about the whereabouts of their clients or other things? Information covered by solicitor-client privilege is protected from disclosure during one of these hearings, but confidential solicitor-client communications are not. Again, lawyers may be compelled to testify against their clients. There are two final provisions worthy of note on the solicitor-client confidentiality issue. The bill will permit the search of a lawyer's office pursuant to a warrant. There's nothing extraordinary about that. The bill, however, is silent on the entire issue of solicitor-client privilege. As many of you know, criminal code provisions recently have been struck down by a number of superior courts in several provinces. The provisions that deal with the process for determining the issue of solicitor-client privilege. In Ontario, it was struck down in the case of Regina and Fink. The entire issue is scheduled to be heard by the Supreme Court of Canada next month. The absence of any mention of the confidential nature of the information that is kept in lawyers' offices or solicitor-client privilege in the bill's provisions sends the wrong message, in my view, to law enforcement officials. There is reason to be concerned that material seized from a law office during a search may not be sufficiently protected from disclosure to the state pending a judicial determination of the issue of privilege. Finally, Mr. Manning talked just briefly about this. The amendments to the National Defence Act will allow the Minister of National Defence to authorize the private communications of a Canadian as long as the target person is a foreigner. This is a very significant change. No judicial authorization is required. The power is vested entirely in the minister. Until now, the Communications Security Establishment, the body that actually does the surveillance, was only permitted to target foreign communications. This new power could be used to intercept or could result in the interception of confidential solicitor-client communications, all on the authority of the minister. Bill C-36, in my view, expands state powers in significant and very disturbing ways. Many of them will deny Canadians the right to independent counsel and intrude on the confidentiality of the lawyer-client relationship. The bill weaves these extraordinary powers into the fabric of our criminal and other laws, making them a part of our legal landscape. The danger to this is that the exceptional measures and powers will become the norm. What will the government do the next time we face a terrorist crisis? They will ratchet up the extraordinary powers and measures that are already there. The further danger to weaving these measures into our regular law is the leakage of these extraordinary measures into the rest of the criminal justice system. We don't have to look very far for examples of this. At the University of Toronto conference on Bill C-36, Professor Oren Gross of the Tel Aviv University spoke about the curtailment of the right to silence in the United Kingdom as an example of this kind of leakage. In 1988, the British government enacted the Criminal Evidence Northern Ireland Order in response to a series of very serious terrorist attacks. The order limits the right of silence to suspect and accused persons during the police investigation stage and the trial. The government proclaimed at the time that these extraordinary measures were essential to combat terrorism in Northern Ireland. Unfortunately, the language that found its way into the order was not confined to terrorist acts, but limited the right to silence of all criminal suspects and defendants in Northern Ireland. 6 years later, in 1994, the British Parliament enacted similar legislation that applies now to the entire United Kingdom. There's no reason to believe that a similar situation could not arise here in Canada. Now, someone who knows something about a terrorist can be called before a judge and compelled to answer questions. What about someone who knows something about a sexual offender or an armed robber? Bill C-36, in my view, is really a piece of emergency legislation disguised as an ordinary statute. A 5-year sunset clause on some of its provisions that can be renewed for a further 5 years with a majority vote in both houses of Parliament will not prevent these extraordinary powers from becoming part of our normal legal process. The aim of Bill C-36 is to provide Canadians with greater security. But greater security at what cost? In my view, Bill C-36 comes at too high a cost, and it's a cost that the Canadians ought not to be willing to pay. Thank you.
Professor Craig Scott. Professor Scott was a Rhodes Scholar, BA from Oxford, and LLM from the London School of Economics. He's a member of the Faculty of Law of Toronto from 1989 to 2000, and now Osgoode Hall. His work has been primarily in the fields of private and public international law, with a focus particularly on human rights as they can be seen in the context of international law. Professor Scott was a clerk to a very great Canadian, very great judge, Chief Justice Dickson. He's worked so hard and well in this field. Like Mr. Manning, he's involved in South Africa, advising the African National Congress while it was still in exile, and on various South African government ministries with regard to it. The whole problem of terrorist legislation and human rights. Interestingly, he served as co-counsel for Bosnia in a case before the International Court of Justice with the responsibility of developing arguments with regard to the jurisdiction of that body. Professor Scott?
See if I can figure this out. Okay. I'm going to take seriously my 15 minutes with good reason and treat it like the red light before the court. I had identified 5 elements that I'd like to talk about, and they were all of a more general nature. They weren't to be focused specifically on Bill C-36, but on some of the issues that cocoon the whole time that we find ourselves in, and the reasons why it's been felt necessary to have that, and what other legal issues arise in international context. But what I think I will do is the first 2 involve really pure public international law kinds of issues in relationship to Canadian law as well. I'm going to skip them because they also involved a fair bit of development of a rule of law notion that I'd be happy to speak to during the question period, but I do fear that I'll get lost in that and not get to the other points. So the first 2 points were to be about the whole law of self-defense in international law, and what, in effect, the world community, to the extent we can talk about a coalition that broad, what, in effect, the world community is lodging their interpretation in to suggest that what's going on in Afghanistan now is, apart from questions of proportionality perhaps, a lawful self-defense. I I've spoken to that before in the context of post-September 11th, and I'd be happy to during the question period. The second point that I'll skip is on the whole problem of the relationship from a broader rule of law perspective of the Canadian Westminster system and the international legal order, and the problems, serious problems of accountability of our involvement in international lawmaking when we have a system where the executive is fused to such a great extent with the legislature in the way that we do. So those are the 2 points that I'm going to skip. And the 3 that I'm going to emphasize have to do with the relationship between evolving Security Council resolutions and interpretation of Canadian law. That's the first. The second is on the whole question of deportation as a tool of combating terrorism, and the whole question of deportation to torture. And the third point is on the positive and negative effects of extradition law, including extradition law of other countries, on the development of international criminal law as a response to terrorism as contrasted to military force. Now, on the first point, the relationship between Security Council resolutions and Canadian law, well, one of the obvious points would be to the extent that there are things that are being required of states to do by evolving Security Council resolutions. And here I would emphasize that the ones that focus on terrorism and Afghanistan do not start September 11th. They start in 1998. And in 1999, the first Security Council resolution mentioning by name Osama bin Laden appears, which is probably, as far as I can tell, unprecedented, that even with the Lockerbie case, the names of the accused were not mentioned in the Security Council resolution. So there is a very interesting build-up to September 11th, and it's sort of in defense of, to some extent, of the tendency to say that a military force has to be part of the reaction. It does have to be said that an international criminal law approach fused to the Security Council was tried to some extent for almost 2 years before the September 11th attacks. Now, after September 11th, a fairly major resolution, Resolution 1373, was adopted on September 28th, roughly 2 weeks after the attacks. And it contains a kind of mini code with respect to how to deal with terrorism. It directs itself to states, and it also helps layer the whole question of individual accountability onto states' obligations. And you have to keep in mind that under the UN Charter, a resolution such as this has effectively an objective effect. It binds all states members of the UN, and by virtue of Article 103 of the UN Charter, it is paramount over all other international legal instruments. So the sort of the supranormativity of Security Council resolutions is a starting point for the following question, which is, as these Security Council resolutions evolve, what heed should our judges be paying to them as part of the interpretive context for interpreting the legislation such as Bill C-36 and other legislation that already exists and has already been used for some time in combating terrorism, or what the government claims to be terrorism. Let me just give you one example before I talk about briefly about the framework that we've received from a recent Supreme Court case on that whole question of interpretive use of an international instrument like the Security Council resolution. Resolution 1373 has as one of its provisions, Clause 2, saying the Security Council decides that all states shall, and then 2E, ensure that any person who participates in the financing, planning, perpetration, or perpetration of terrorist acts is brought to justice, and ensure that in addition such terrorist acts are established as serious criminal offenses in domestic laws and regulations, and the punishment duly reflects the seriousness of the acts. So quite apart from a host of terrorist conventions, what effectively has happened is a kind of incorporation by reference of terrorist conventions that already exist and are fairly widely ratified, but certainly not universally ratified, into a universal duty on states to criminalize a broad range of conduct that's going to be called terrorism. But what I left out in reading that, and I'll now reread it, who participates in the financing, planning, preparation, or perpetration of terrorist acts, or in supporting terrorist acts, is brought to justice. So this tag clause of or in supporting terrorist acts, there is no clear international criminal law understanding of what those words could mean. And when, as a Canadian, you watch House of Commons debates and see one of the leaders of the opposition, Stockwell Day, within a few days, calling on the government to start rounding up and deporting people who support terrorism because they have no right to be in this country if that's the kind of conduct they engage in. When a word can be used in that context and that loosely, one worries quite a bit about what content can be shoved into that. What is the intent? This is just one example. There may be many other more technical issues that there's something in the Security Council resolution that adds some light that isn't specifically addressed in terms in a piece of Canadian legislation. To what extent should our courts, in the guise of interpretation, read in that kind of, those kinds of provisions? Now, the framework for this, of course, I shouldn't say of course, but the framework for this is a recent case called Baker, in which the Supreme Court of Canada said that judges may, and there was a lot of hints that they should, but didn't quite go that far, use international human rights treaties, in particular, to interpret domestic statutes, even if those treaties have not been implemented or have only been implemented in part by Canadian legislatures. And so it's created a kind of rule of law fusion between international treaties in the human rights realm and the ability of judges to give content to, say, very open-ended administrative discretion, etc., in light of human rights. Now, this is going to play a very, very important role to the extent that discretion is part of the whole framework in which Bill C-36 and other laws will operate in combating terrorism. But it will also raise the question of, is what is good for the goose good for the gander, which is, does the principle that you should interpret domestic law as much as possible in light of international law so as to harmonize the two, does that apply with equal force to international norms dealing with the fighting of terrorism through measures that presumptively are rights infringing? And what I would like to say, without being able to develop it here, is that there's a strong argument that the presumption of interpreting domestic statutory law, including administrative law, in light of international law, really does have a special relationship to international human rights law. It has something to do with a kind of a broader rule of law notion where the values, the constitutional values and the international values have such a correspondence that judges should actually actively consider the international normative context in giving content and constraining the state, even without explicit incorporation. But what about rights infringing international law? That may be there for all kinds of good reasons, as we know it is. Should judges be in the business of doing the work for the legislature, where there isn't clear implementation? Should the principle of interpreting Canadian law in light of international law actually play right across the board? Or should a strong difference be made between using international human rights law and other forms of international law? Actually, I suspect there might even be a debate here, if we ever had time for it, between myself and Justice Corey, because I think his own views on the evolutionary content of interpreting statutes includes law generally, if I read his dissent in the Pushpanathan case of some time ago correctly. But it's a question that needs to be asked. Now, the second point is the torture and deportation issue, deportation for reasons of national security. I am not going to speak to this in any depth because somebody who's coming up behind me knows far more about it. And as she jokingly said to me before I stood up, that she might indeed be one of the first ones charged under this legislation after she was listening to the talk before mine, Barbara Jackman. But many know that there's a case pending before the Supreme Court, the Suresh case, which deals with Canada deciding that it wants to deport a person accused of being a fundraiser for the Tamil Tigers, Mr. Suresh. And one of the issues, there are a host of issues, one of the issues is whether or not this can be done despite the fact that there appears to be substantial risk of him facing torture if sent back to Sri Lanka, given all kinds of things. And what I want to say here is that nothing should change from a legal perspective if one takes international human rights law seriously. There's nothing about September 11th that should change that, the result that the court is going to come to in that case. I can't see the court changing the result because of the events. It's not the way it works, not the way the judges think of their own integrity. But for those who are expecting that September 11th should make a difference, my argument is that it should not. And one of just the very positivistic reason for that is, quite apart from the humanistic values one would bring to bear, is that freedom from torture is one of the non-derogable rights in all international human rights instruments, even in states of emergency. Well, I shouldn't say even in. In states of emergency, certain rights are non-derogable in the sense that they cannot be cut back because of the existence of an emergency. The Committee Against Torture has just reiterated a finding that it has brought against Israel a few times in the last few years, that certain interrogation techniques used by Israel do cross the line, do constitute torture, and that the lingering existence of a few of those techniques, or the unclarity as to whether they have actually been finally banned by Israel, is a violation of the Convention Against Torture. And they make this finding knowing and acknowledging explicitly the serious national security context that Israel has always faced and the heightened context that it faces right now. So the whole issue that certain rights have to be taken seriously in an ultimate sense is something that just cannot go by the board. Now, some of you may say that he's beating a dead horse here. All I would say is that I have had conversations with as senior as you can go in CSIS at one point. And the person in question actually said, when push comes to shove, there are certain kinds of terrorists who should be deported regardless of the consequences. Okay? That includes even if we know, not just suspect, that the person will be tortured. And this had a lot to do with the person's sense of a kind of battle that was being fought. This is, for good or bad reasons, from their perspective, part of the fabric of the discretion that will be brought to bear on the question of fighting terrorism after this bill goes into effect. I'm certainly not going to reveal who I was speaking to, but I can tell you that I have my own views that it's not necessarily a lone view in CSIS. The third point I'd like to make, and not having even looked at my watch to know when I should stop. How much time do I have?
2 minutes.
2 minutes, good. Extradition law. We all know that your friend and mine, and Baltasar Garzón in Spain, the investigating magistrate who went after Pinochet and everybody else under the sun in South America, has had arrested 8 suspects who he claims are part of Al-Qaeda, and has made it known, he and actually not just him, but the prosecutorial authorities in Spain, that they have no interest in extraditing these 8 persons to the United States for 2 reasons. One is the existence of the death penalty as a possible outcome, and the other is unfair trial considerations having to do with the military trial apparatus that the Americans have put into place. Some of the quotes coming out of Cheney and Ashcroft are frighteningly medieval and scary in the way in which they actually say that the fact that a person is accused and we believe that they're a terrorist means they do not enjoy the rights of the U.S. Constitution, even if the trial is being held under our law. Therefore, all of these elements of secret trials, not always but possible, etc., are perfectly justified. Europe is taking a strong stand against that. And with the death penalty thing, this is nothing new, but there is an evolving norm that says that if you've abolished domestically the death penalty, you have a duty, not just a power, to refuse to extradite and put a person at risk in another country that does have the death penalty. Now, all of this is kind of interesting from a rule of law perspective because it does discipline the U.S. Certainly in an ironic way by highlighting a pervasive strain of illiberalism in the country that presents itself as the defender of freedom. It also helps to deterritorialize the fight against this form of terrorism by making it much more likely that solidarity prosecutions will take place outside of the U.S. because countries will have no choice. They have bound themselves not to extradite, and they're certainly not going to want to let these folks go free. But the negative effects, and I'm going to end here, on the whole hope of a lot of people that whatever justifications are involved with the military instrument here, an international criminal law response with really deep cooperation between states, that includes intelligence cooperation, is the best way to go. The irony and perversion may be that this refusal to extradite from European countries may create a tendency in the U.S. to continue to choose the war mode, including killing over arresting, as the best way to go. If we can't get them, if you won't give them to us, we'll make sure something else happens. And the other concern is that courts themselves may begin to see themselves as partners in a broader struggle and begin to roll back some of their legislation, some of their judgments about protecting rights in the extradition context. What I would hope is that Europe will not be alone in this, and that Canada, not just waiting for the judges, but having our executive finally step up to the bat on some issues that we don't agree with on the U.S., will actually say, we agree with Europe on this. So I was probably very wise not to address the first 2 points because I just got through those 3, and I'm happy to address any questions on the whole broader public international law self-defense questions in the question session. That's all. Yeah.
The next speaker is Barbara Jackman. She'll probably be well known to many of you. She's certainly well known to all the members of the court in Ottawa as an outstanding counsel. Her work in the field of immigration is exemplary. She's been a delegate to the Northern Ireland Peace Process fact-finding mission. Now, a peace process in Ireland, I can say this with my background, is something of an oxymoron. But, oh, God willing, it will come in time. I thought that wonderful picture of the Protestant mother and the Catholic mother linking arms at the head of the parade and walking down the streets of Belfast was a vision of the future. It's something that will come later. Something wonderful that can be acquired and wonderful, and perhaps credit to Canada, that none of the Irish troubles follow Irish people in Canada. Barbara's work in the cases is legendary, from Singh through Baker and Suresh coming up. She's demonstrated a passion for human dignity, and it's been recognized by an organization that's close to my heart, the Advocates Society. And she's been awarded the Advocates Society Justice Award in the year 2000 for her work in representing disadvantaged or unpopular clients. Marvelous honor for a wonderful counsel.
This works. I was thinking when Justice Corey talked about the Advocates Award that it's not going to help me when I get arrested under the anti-terrorism legislation. That is scary. I hadn't really looked at the legislation from the point of view of a lawyer, but certainly with an office full of alleged terrorists, we receive funds from them and certainly have a lot of information that they've given us. I've gotten so paranoid about terrorism cases that I don't put any of my notes on my computer. I keep them all in writing just so CSIS can't pull them off through the internet. Anyways, I'm going to talk about 2 things. One is the the terrorism aspect of the anti-terrorism legislation in light of what you may expect because of what's happened in the context of immigration law. And I'm going to talk about the process and give my view on why I think everything's been put with the federal court and the federal crown and taken out of the normal stream for criminal cases. But first, in terms of terrorism, it's interesting when the anti-terrorism legislation was brought forward in the House of Commons, it started a very intense public debate about human rights and what is terrorism and how restrictive the law can be in terms of persons' rights to associate and to express themselves freely. What's really interesting about that is that since 1992 we have had a terrorism regime under the Immigration Act, and there has been not a peep out of anybody in Canada about the human rights violations that Canada commits against persons who are not citizens. The terrorism provisions in the Immigration Act provide for no definition of terrorism, and I want to read you what the federal court has said terrorism is. Justice Mackay and McAllister said terrorism is defined by dictionaries, and a definition from the Webster's Dictionary is included in Mr. McAllister's application. It is there defined as using terror and violence to intimidate, subjugate, etc., especially as a political weapon or policy. That's any war. That's any violence. Where it's involved with politics, it includes state. It's a very broad definition. In Ahani, I think it was Justice Deneau said, in my view, since Parliament has decided not to define these terms, one of them being terrorism, it is not incumbent on this court to define them. He says, as to terrorism, while I agree with counsel for the respondent, that was me, that the word is not capable of a legal definition that would be neutral and non-discriminatory in its application, I am still of the opinion that the word must receive an unrestricted interpretation. And when we argued that it wasn't neutral and it wasn't non-discriminatory, it was because the legislation is used primarily against countries that Canada is not allied with, or against national liberation movements that are facing severe state repression in their countries. And Canada never goes against the governments. It only goes against the victims of state repression and never the oppressors themselves. It is only the victims who are terrorists, not the states that do it, that cause them to take up arms against it. So that's why the court said it doesn't matter if it's not neutral, it's not non-discriminatory, it's still as broad as we think it is. In Baroud, Justice Deneau again said that he's mindful of the fact that the terms terrorism and terrorist are not defined. Counsel for the Minister affirms that, like beauty, the image of a terrorist is to some extent in the eye of the beholder. Justice Deneau went on to say that, again, that there was no need to define terrorism, that it was to be applied in very general terms, and it must receive an unrestricted interpretation. Mr. Justice Teitelbaum in Suresh, I think, had the best definition of all. He said, as I have stated, he says, counsel submits that I should determine the content of the term terrorist or terrorist act. I do not believe it is necessary to do so. As I have stated, one can see a terrorist act, and I am satisfied that act must be seen through the eyes of Canadians. His way of looking at it was, he says, I'm satisfied there's no need to define the term. When one sees a terrorist act, one is able to define the word. So what was for Mr. Justice Teitelbaum a terrorist act was a terrorist act. Justice Teitelbaum found in Surish's case that attacks on military targets were terrorism. And in fact, 90% of the allegations against Surish were attacks by the LTT on military targets, not civilian targets. It's questionable now if terrorism is limited to non-military targets, whether Surish would have even been found to be a security threat on the evidence before the federal court security judge. So what's happened in terms of how terrorism is applied is, I think, and it's going to raise a number of problems under the anti-terrorism legislation. First of all, because of the broad definition, terrorists are journalists who write. We have a journalist who wrote for a PLO magazine. She is a terrorist because she was a journalist writing for a PLO magazine. We have a woman, a Palestinian woman, who worked through the Fatah Women's Organization to provide food and clothing to the victims of Sabra and Shatila. That was a refugee camp where many non-combatants were massacred by Falangist forces in Lebanon. The only organization for a Palestinian woman to work through in the area where she lived was the Fatah Women's Organization. She's a terrorist because she worked in the Fatah's women's organization. There are many cases where people have worked within the community, and I'll give you an example of a Canadian. This is a senior civil servant that lost his job in the Canadian government. He was found not to be loyal because of a CSIS security report. His crime was he lobbied with members of parliament to stop the deportation of Suresh from Canada, where he thought Suresh would face torture in Sri Lanka. So he lobbied with parliamentarians, and he testified in Suresh's case about conditions in Sri Lanka. Because of that, he's a terrorist, and he lost his job in the federal government. So you can see it's been very broadly applied. I don't expect under the anti-terrorism legislation, even though there is a definition, that it will be applied in a less restrictive way. It will be applied as broadly to as many people, I expect. The other question in terms of the terrorism definition, unlike the Immigration Act, it excludes armed conflict. It says that acts in accordance with customary and conventional norms for armed conflict would not be considered terrorist. I don't think that will help the organizations that are engaged in national liberation struggles against repressive states, because there are very few organizations that have been recognized as national liberation movements. National liberation movements, certainly under international law, have a right to take up arms against an oppressive or an occupying state power. And as long as they stick to military targets, it's justifiable. If an organization is not a national liberation movement, then any attacks against a military target may be seen to be non-legitimate and may be seen to be terrorism. If you look at the principal sort of national liberation movements going on in the world now, the Kurds against the Turkish government, the Tamils against the Sri Lankan government, the South Sudanese against the Muslim Sudanese government, all of those organizations have not been recognized internationally as national liberation movements. So it is very possible that a broad definition of terrorism will include armed, legitimate targets in terms of military law, because they're not national liberation movements with a right to take up arms against a state. Certainly that problem would apply to the Tamil Tigers, which is what the organization that the government, well, not just the Tamil Tigers, they put the Kurds on their list of terrorist organizations as well. I think the third problem with respect to the anti-terrorism legislation, which is apparent in the immigration practice, is that it is going to focus primarily on non-governmental organizations. You may find that the government says that the state of Afghanistan and maybe the state of Sudan are supporting terrorism, but in the past, it's certainly been the non-governmental organizations within countries that are fighting against the country that have been characterized as terrorists. I don't know, we have not been able to succeed in any selective application of the law arguments in the cases that we've had, but it may be in the criminal courts that you would convince a criminal judge, and I think there is a very different history between the criminal courts in Canada and the federal court. You may be able to convince them that there is a selective prosecution element to this in terms of who's being targeted. There's two more points that I want to make about the provisions. The facilitating terrorism and the fundraising for terrorism are provisions that are going to have a profound impact on the immigrant communities, because many people come from countries, they come as refugees from countries involved in armed conflict. They have family and friends left in the home country, and they certainly do want to support them financially and otherwise in terms of both providing for provisions when they don't have enough in those countries, and assisting in some cases in helping with the armed conflict, because they see it as the only way to free their people from state repression. I expect that there are many organizations and individuals that could face criminal prosecution because there are many organizations involved in fundraising. The problem with the legislation will be whether or not the government focuses on community organizations. If you take, for example, the Sri Lankan context, there's an organization, the Tamil Rehabilitation Organization, which is an independent organization which assists the internally displaced in Sri Lanka. It is not part of the LTT at all in terms of legal terms. They're very different entities. But because it operates in the areas controlled by the LTT, it certainly has a close relationship. The LTT is already on the list. If people give money to the TRO, are they fundraising terrorism? Under the Immigration Act, they certainly are. Because the way the government looks at it is if you provide humanitarian assistance, it frees up money that the organization would otherwise have to use for humanitarian assistance. They can now use it for arms. So it's been very broadly applied. Humanitarian assistance comes within the rubric of fundraising for terrorism. That was the case for Suresh in terms of the facts before Justice Teitelbaum. So I think that people who are engaged in legitimate humanitarian fundraising, because of the realities on the ground in many of these countries, will end up being targeted as fundraising for terrorist organizations. The other reality of some of those situations is that there are no other organizations to fund through except the so-called terrorist organization. If you take the PLO, for example, in the West Bank, before the Palestinian Authority went in there, money was brought in to the West Bank through PLO organizations. That was virtually the only way you could bring money in, and it was brought in underground because of the controls that the Israeli government had put on fundraising going into that area. So if the only organization you can put the money through is the PLO, and you want it to, say, fund a hospital, you're going to get caught by the terrorism provisions because of the realities on the ground in the area where the person wants the money to be sent to. I think the fifth sort of point that I wanted to make about terrorism is that I think what will happen is the government will use the criminal investigation process in order to substantiate cases for deportation. They will not have sufficient evidence to support a criminal prosecution, but the police will investigate for immigration effectively through wiretaps and whatever, and they will have enough to be able to deport people. Under the Immigration Act provisions, there only has to be reasonable grounds to believe that the person is a member of a terrorist organization. You don't have to show facilitating, you don't have to show engagement in terrorism by the person themselves, just mere membership. The way membership has been interpreted by the federal court has been very broad, so that it covers persons. In fact, we just got a case, I guess 2 weeks ago, where the adjudicator said member doesn't mean member. Member means if you supported them in any way. That member is broad enough to cover someone who is not a member but who has supported the organization. That's how broad it has been because of the way federal courts interpreted it. So I think what they'll do is they won't have a case to found a criminal prosecution. They'll just take it and they'll use it to deport people on the grounds that they have reasonable grounds. The last point I wanted to make, how many minutes? I have enough? 2. Oh, this has got to be really quick. This is probably going to sound bad, but I want to put it in context. When I was in Chile in 1984, I was at a lawyers association meeting in which a lawyer, Garraton, who's now a rapporteur for the United Nations, was talking about the law of habeas corpus. On September 11, 1973, there was a coup. September 13, 1973, the Chilean courts threw out habeas corpus. That was the end of habeas corpus under the Pinochet dictatorship. What was really startling for me was that the judges that threw out habeas corpus were judges that had become lawyers under democracy, been appointed to the bar under democracy, and as soon as the dictatorship was put in place, they became supportive of the dictatorship in effect. Every time I look at a judge since I was in Chile, I keep wondering, would you be the same as the judges in Chile if we had a situation like that? That's my preface to the federal court. I'm not comparing the federal court to judges in Chile, but I think that the government moved cases to the federal court for a reason. They put the secret evidence before the federal court rather than before the criminal courts because the criminal courts are used to disclosure. The federal court is used to not having to provide disclosure. I'll give you an example. The Security Intelligence Review Committee hears secret cases like the federal court does. The committee cross-examines witnesses in secret. We get the expurgated transcript. We're allowed to cross-examine the secret witnesses, the CSIS officers. They may not be able to answer all the questions, but we can certainly cross-examine them. I did a case in federal court 2 weeks ago. Justice Tremblay-Lemaire, when I said I wanted to test the evidence, she said no. The person has to present his case first, then maybe she would let us test the evidence. We asked her to go in camera so our client could explain why he couldn't testify in public. No, he had to go in public and then she'd think about it afterwards. So we didn't call the client as a witness. The federal court does not ever disclose information that is provided to them in secret. I don't know of a single case where the federal court has disclosed. They impose no obligation on the government to go to the country and see if the country is prepared to have the evidence disclosed. And I'll give you an example. We got Interpol telexes relating to one of my clients in an inquiry. That evidence was used before the federal court judge. I asked for it. He wanted to know how I found out about it. I said it had already been disclosed. The judge wouldn't disclose it. I already knew what it was. I already had copies of it. It couldn't be disclosed in the federal court process. They will not disclose anything. It's clear in that case that the government gave permission for it to be disclosed publicly, but the federal court judge still wouldn't disclose. The other problem with the federal court process is that recently some judges have started to test the evidence, but the practice for most is that they receive affidavits from the government and that's accepted and it is not tested or questioned at all. You can never overcome a case where the evidence is accepted as true in the first instance, and then you have to show why it isn't true when it's not being tested at all. There's a case in the Indian Supreme Court where they said that was rubber stamping an executive decision, the failure to test the evidence. Our federal court judges, for the most part, do not do that, do not test the evidence. I think that the cases have been put there because the government of Canada knows darn well that whatever they want to do will be upheld by federal court judges. And I mean, I wish I didn't have to say that, but that's the practice. That's the way it's always been, and I think that's the way it will continue, and that it will create a real problem for criminal judges when they get this evidence before them and they realize it could have been disclosed, and they're not allowed to disclose it to give the person a fair trial. So, anyways, that's it. Oh, shit.
We're now going to hear from Stanley Cohen. He's a Senior General Counsel, Human Rights Law Section of the Department of Justice, and as such provides legal advice to government on matters affecting the Charter and the criminal justice system. He was a criminal practitioner in Manitoba before joining the Department of Justice in 1978. Although he specialized in criminal law policy and as an advisor on the Charter of Rights and Freedoms, he had also had a substantial tenure as a coordinator of the Criminal Procedure Project of the Law Reform Commission of Canada. From 1995 to 97, Mr. Cohen served as Secretary to the Commission of Inquiry into the deployment of Canadian forces in Somalia. He has associated with the Faculty of Law, University of McGill, University of Ottawa, Toronto, and Manitoba. And before he speaks to you, I should say that Mr. Cohen, in my mind, is the epitome of all that a civil servant should be. Learned, patient, and carrying out instructions of the government to the best of his ability. Mr. Cohen is not a politician, far from it. He's a very able lawyer, counsel. And he's dealing with legislation that's in the nature of emergency legislation. It might be compared to a War Measures Act. It's a little easier in the war with an identifiable enemy. But there was then, there's now, tremendous concern for the safety of public water, public facilities, hydro. There were terms such as the fifth column, and in Norway the term quisling for a traitor. And it was thought then, I think probably rightly so, that for the period of the emergency, special measures were needed and required to combat that emergency. In any event, far too long, and now hear from Mr. Gold.
Those of you who don't know Mr. Justice Corey know that he's famously gentle and good-natured, and therefore I'm going to ask him for some extra time. My task is obviously a little bit different from that which the other speakers have had. I basically have attempted in the work that I carry out to advise the government on the constitutionality of the measures that were under consideration. And that is obviously the essence of this exercise, the need to balance the competing demands of security and freedom, liberty. And that can sound like high-flown rhetoric, but obviously it is not, because of what we're forced to confront. Basically, I think we should start our consideration, at least of this matter, from the perspective that I approach it from, with that question of whether the world has in fact changed since September 11th. Informed and reasonable people actually come to different conclusions on this question. I asked, did the world change when the telephone was invented? Did it change with the introduction of computers or the internet? Did the world change with the detonation of the first atomic bomb? Did it change when the twin towers of the World Trade Center collapsed? To a certain extent, how we answer this last question has an important bearing on our view of Bill C-36. I don't think that can be avoided. Like many of you who are here, I grew up at a time and in a place where people did not lock their doors. As children, my sisters and I went from house to house without very much in the way of formality or impediments blocking our way. Of course, in 2001, that world no longer exists. Doors are bolted, and beyond ordinary locks, people now install burglar alarms. I regret the passing of that time and of the sensibility that spoke to it, and I have no great affection for that which has replaced it. But in any event, we now find ourselves in the world that has produced Bill C-36. And as the look on all of your faces indicates, these are very sobering times for civil libertarians. In the time since this legislation was first tabled, various speakers have suggested that as a nation we have been too quick to accept what is permissible. Other commentators have suggested that the process of what they described in another conference that I spoke at as charter proofing should do little to quiet the anxiety that is felt about adopting extraordinary measures to respond to exceptional threats. And still others have suggested that what we are now witnessing in terms of legislative invocation rivals and perhaps even surpasses the invocation of the War Measures Act in 1970. I personally feel that that particular comparison is not an apt one. The War Measures Act was characterized by an almost total absence of remedies and redress. October of 1970 was a time of arbitrary arrest and detention, of unreasonable search and seizure, and of curtailed due process. This, too, we all have to admit, is admittedly a dark period. But we do have a Charter of Rights and Freedoms, and for that I suggest we should be grateful. It is, of course, something we must also recognize is that our charter does have its limits, but the values that it espouses are fundamental and should not be denigrated. The charter has made a difference in the production of this legislation. I don't know, but perhaps you could just do a show of hands and tell me how many of you have actually seen the legislation that we're discussing today. How many of you have read it? I think that, of course, how many of you have understood it is a second question. The bill is obviously fairly monumental and extremely complex, and when Morris Manning, my friend, stands up and explains in an overview of 15 minutes exactly what these provisions accomplish, it's baffling, and to a certain extent, like any simplification, it has the potential to mislead. I'm not suggesting that he has misled you in his summary. His summary actually was very powerful, as were all of the statements that you heard here. And I think that this is something that is food for all of us to take away. This process, of course, is not complete. The House of Commons has only reached the third reading stage today, and the matter will still go before the Senate. But the Charter has its limits. The values it espouses are fundamental. Under the Charter, the Supreme Court of Canada has recast the rule of law as now embodying what is called a culture of justification. It is to the question of justifications and safeguards that basically I wish to address my remarks today. Just a word about this issue of charter proofing. The Charter is not something that is used in order to establish the outer limits of legislation and to say that we'll take the legislation up to the point that the Constitution allows but no further. What is important, I think, is for us to take a look at this particular juncture in this particular troubling context as what is going on around the world. If we look to the legislation that has been enacted or is under consideration in England or France or the United States or Australia or New Zealand or Germany and on, what we discover is that in important respects, the limits that have been placed in Bill C-36 are not as far out as have been placed elsewhere. And I'm sure that all of you on a daily basis are reminded of this when you see the newspapers and understand exactly what is being proposed as measures in other places. But Bill C-36 nevertheless does contain extraordinary measures that are designed to respond effectively to the unprecedented threats that have been posed by global terrorism. Strong measures have been adopted. And naturally, when we look around the world, there has been a certain symbiosis in the development of policies and the development of legislation with regard to the measures that are being brought forward. But nevertheless, this legislation has been drafted against the Canadian reality and with the Canadian reality in mind. The most controversial measures contained in Bill C-36 in one form or another, we all recognize, can all expect to meet with challenges that are based on violations of the Canadian Charter of Rights and Freedoms. Those of us who worked on this legislation believe that these measures will be capable of withstanding these challenges. Nevertheless, since these measures do in fact have the capacity to infringe or impinge upon the individual liberties of citizens and all those who reside in Canada and their civil rights, these challenges should not be regarded as being based on specious or trivial objections. Quite the opposite. It is expected that the courts will find that the Charter is engaged when considering these objections. Although it is possible that the courts may find that many of, if not all of these measures can be justified within the confines of the very right or freedom that is allegedly infringed, for the purposes of this particular discussion today, it's more useful to consider these measures in terms of the kinds of justifications, the Section 1 reasonable limits terminology that might be offered in their defense. An appropriate starting point for this kind of discussion is with a general examination of the national security justification itself. This justification has application in a general way to virtually all of the measures that are contained in the proposed Anti-Terrorism Act. This is not to say that individual measures do not require individual justification. Rather, the more general observations that are offered by me today underlie and should be considered along with the particular specific defenses and safeguards and other justifications that can be marshaled in support of individual measures. National security itself is arguably the most important justification that can be advanced in support of legislation, springing as it does from the necessity to safeguard and preserve the very existence of the state and its democratic institutions and ensure their continued survival. The need to safeguard the security of the nation can also be rooted in the ability of the state to take measures to protect the national interest, conduct its national defense, or in the power to ensure that laws are passed that safeguard the peace, order, and good government of Canada. The Charter begins with a preamble that states that Canada is founded upon principles that recognize the supremacy of God and the primacy of the rule of law. The primacy of the rule of law is thus a reference point for all Canadian legislation, including those that address national security. While the rule of law comprehends the existence and maintenance of public order through the systematized application of the threat or the threat of force by a modern state, it's more than that. It is a position of all advanced democracies, including Canada, that our law's claim to legitimacy also rests on an appeal to moral values, many of which are embedded in our constitutional structure. The rule of law principle therefore requires that all government action must comply with the law, including the Constitution. And there I've been quoting, in effect, from Supreme Court jurisprudence. The collective rights of all persons to whom the protections and guarantees of the Charter extend must include the right to peace and security. Order and security under law are preconditions to the maintenance of the rule of law. The rule of law, again quoting, vouchsafes to the citizens and residents of the country a stable, predictable, and ordered society in which to conduct their affairs. The ability of a state to take measures proportional to the threat posed to preserve itself and ensure its continued survival is undoubted and is reflected in the doctrines of necessity and self-defense. International instruments, including the International Covenant on Civil and Political Rights, recognize, as Section 1 of our Charter does, that the rights detailed are not absolute. Rights must be subject to, or may be subject to, limits in accordance with such procedures as are established by law, as well as limits based upon grounds of public order or national security. The ability of the state to take strong measures as part of national security, legitimate self-defense, and for the protection against the threat of global terrorism is well recognized in a host of international instruments that have been ratified by Canada. Beyond these considerations that bear on the question of the general Charter justification for these measures, the legitimacy of the claim that strong measures can and should be taken in a time of in the name of national security, while still adhering to constitutional dictates, is evidenced by the existence of similar measures, but as I've mentioned before, in many cases more extreme measures taken in what are regarded by the courts and by most people as other free and democratic societies in response to the threat of global terrorism. The need for strong measures does not require the abrogation of Charter principles and values. The Charter is a flexible instrument, which thus far in its history has evinced considerable sensitivity to context and to circumstance. Constitutional jurisprudence does not insist upon inflexible and immutable standards. Depending upon the context, societal needs can result in the alteration of the Charter standards that might be otherwise applicable in a given situation. Even prior to the introduction of Bill C-36, national security had been recognized as a valid justification for the adoption of special measures which may have the effect of abridging procedural rights that might otherwise accrue to individuals. In instances involving the security of the state, departures from charter standards have been recognized, such as the reasonable and probable grounds standard. In this regard, it's worth remembering Mr. Justice Dixon's words in Hunter versus Southam, where the state's interest is not simply law enforcement, as, for example, where state security is involved, or where the individual's interest is not simply his expectation of privacy, as, for instance, where the search threatens his bodily integrity, the relevant standard might well be a different one. Before addressing the question of justification in terms of the procedural safeguards that exist in many of the measures that you've heard reference to, I would pass on to one or two observations about what I consider to be virtues of Bill C-36, and that is a word we haven't heard yet tonight. First of all, there has been no use of the override or of the notwithstanding clause. I say this is a virtue because the use of the notwithstanding clause actually contracts or shrinks the area of rights that are available and exercised by a citizen. The virtue of this legislation is that it preserves for the citizen and for affected persons the right to question whether the legislation does in fact get it right. This is an aspect that should not be understated, and this is something that all of the lawyers who have spoken thus far will be using in their particular circumstances and contexts that they have mentioned. Another significant aspect of this bill is to be found in its deliberate limitation to terrorism and terrorist activities, and the preclusion of the extension of the legislation to ordinary law enforcement investigation powers and procedures. This is a self-imposed fetter on state activity that allows for an effective response to the direct challenge that must be confronted, while at the same time limiting the opportunities for manipulation and abuse. Now, I obviously can't deal with many of the circumstances that have been raised, but I will deal with two of the most controversial provisions that have been mentioned by the witnesses who have appeared in front of the House and Senate committees that have considered the bill. The first deals with preventive arrest. The preventive arrest procedure allows for a period of detention prior to final judicial determination that may effectively run for 3 days. Provisions in other comparable jurisdictions are not as balanced. In the United Kingdom and in the United States, in their preventive arrest situations, the 7-day period is at least presently applicable, and extensions of those particular periods are being considered. Save for emergency or exigent circumstances, this substantial power of preventive arrest can only be invoked with the consent of the Attorney General. The section is modeled on the bail release provisions. It's a recognizance provision and contemplates a judicial hearing within 24 hours. Additional safeguards include judicial supervision of the recognizance process, a reasonable grounds to believe requirement that the terrorist activity will be carried out, the requirement that an arrest without warrant can only be made where it is necessary to prevent the commission of terrorist activity, and the ability by a person to vary a recognizance. And basically the whole thrust in this particular preventive arrest determination is to release. The purpose is obviously to try to disrupt something that is nascent or incipient, but the orientation of the legislation is to release on conditions. Investigative hearings. This order requires witnesses to testify under oath at the early stages of an investigation. Despite impressions to the contrary, this procedure is not unprecedented. Compelled questioning occurs and exists in securities law and in public inquiries, fire marshal, and coroner's inquests. It's been used extensively in Canada since 1988 in relation to the Mutual Legal Assistance in Criminal Matters Act, which means that other jurisdictions can come into Canada and compel people who are in Canada to answer questions pursuant to this act. That act has withstood judicial review and constitutional scrutinies. Under these new provisions, the citizen must answer questions, but is extended self-incrimination, subsequent use, and derivative use immunity protection. Also, while the individual is compelled to testify, laws relating to non-disclosure of information or privilege continue to apply. The right to counsel continues to apply in this setting. Also, as regards cases of compelled testimony in relation to future events, as contrasted with situations where terrorist acts have already been committed, the prior consent of the Attorney General is required before an application for compulsory questioning can be brought. The standard on which an order is obtained is based upon a charter-consistent reasonable grounds to believe standard. There must also be reasonable grounds to believe that the person sought to be compelled has direct and material information that relates to the offense or that reveals the whereabouts of the person who the peace officers suspect may commit the offense. Reasonable attempts must have been made to obtain the information from the person before this order can be made. The legislation also provides the judge with the authority to include in the evidence gathering order terms and conditions to protect the interests of the witness or third parties. Another provision that has come in for considerable scrutiny has been the definition of terrorist activity. Allegations of vagueness and overbreadth have been directed at certain aspects of this definition. The main argument that has been advanced up till this point was that the provision had the capacity to embrace legitimate political activism and dissent, including union activities and student protests. These concerns were meant to be addressed initially in the insertion of a defense formulated in terms of lawful advocacy, protest, dissent, stoppage of work, except where this activism is intended to result in serious forms of specified harms. However, questions were raised whether, because of the use of the word lawful, activities involving civil disobedience that include unlawful conduct, such as assault, trespass, and minor property damage, might be interpreted as being terrorism. This was never the intent of the legislation. Obviously, the fact that an activity is otherwise unlawful does not by itself mean that it amounts to terrorism. In light of this, an amendment has been inserted removing the word lawful. This would not have the effect, obviously, of making protests lawful that are otherwise unlawful due to violations of other laws. It would, however, clarify that this specific exclusion from the scope of the definition of terrorist activity applies whether or not advocacy, protest, dissent, or stoppage of work is lawful. I would like to say a word or two about the vulnerability of lawyers to prosecution under this particular act. You have been treated to a strong statement in this regard. The suggestion that lawyers could be seen as committing the participation offense when they provide legal services to an entity wrongfully labeled as a terrorist group, or in any other circumstances where they are only providing legal services to a person that is accused of being a terrorist, in my view, is misleading on the import of what Section 83.18 of the bill actually provides. In reality, Bill C-36 only makes it an offense to participate in the activities of a terrorist group if the participation was for the, and I'm quoting here, the purpose of enhancing the ability of any terrorist group to facilitate or carry out a terrorist activity, a specific intent requirement. When lawyers provide legal services to accused persons or suspects, their purpose is to advise those persons of the law that applies to their case. They cannot, and we all know this, they cannot lawfully offer or provide services for the purpose of enhancing their client's ability to facilitate or commit any criminal activity, let alone a terrorist activity. I can basically conclude that this is about as much as I'm able to say in the time that's been allotted to me. It is possible to go on and examine the other major provisions in Bill C-36 and enumerate the safeguards that are employed there as well. You will see if you go through the legislation that there are, with each contestable area, standards of mens rea, the right to counsel, judicial review, oversight, and the like. Also, there have been significant amendments that have not been announced, significant amendments that have been announced that should not be overlooked. These include, as I've mentioned, the definition of the terrorist activity, the introduction of an annual reporting requirement, the insertion of sunset provisions regarding compelled questioning and preventive arrest, the subjection of the ministerial use of certificates to a process of judicial review. Okay. I won't go further with the amendments, but there certainly is, with respect to oversight and the like, much that could be said in terms of judicial review, ministerial review, annual reporting, and so on. I guess my basic point in all of this is that this is indeed broad, significant legislation with a dark face to it. Legislation with a demeanor that some have characterized in extreme terms, and I understand the impetus behind that. This legislation has the capacity to affect the lives of all Canadians, and we are right to be concerned about it. We have the right to raise significant questions, but many of the warnings that have been sounded are warnings only. They are not indications of the manner in which the legislation is going to be enforced or the manner in which it will be overseen. We have had speculations about judicial rulings, etc. This legislation is meant, and I think one of the key features of it is meant to be applied in a way that respects the Constitution and applied and used in a manner that is non-discriminatory and respects the basic rights and freedoms and equality of all Canadians.